Welcome back to Contemporary Business, and we delve into critical issues shaping the business world, both in South Africa and obviously elsewhere as well. I'm your host, Ivor Blumenthal, and thanks for joining me. I want to explore a topic that's as challenging as it is fascinating: the ethics and the legalities of poaching. Poaching staff within companies and between companies that are all members of one industry association. But before we dive in, let me paint a picture for you. Imagine you're the chief executive officer of a mid-sized company that's part of an industry association. Over the years, you've worked hard to build a collaborative network with other member companies. You share insights, you support each other, you network, etc., etc. But recently, you've noticed something troubling. Several of your top performing employees have been lured away by another member company, one with deep pockets and a hunger for growth. They offer better salaries, enticing benefits, and they promise rapid career advancement. And not just at your senior levels, but more worrisome at your operational levels in your business. Now, as you watch your talent walk out the door, you're left wondering, has this crossed the line from fair competition to unethical behavior between our companies? More importantly, if you think that's the case, that there has been unethical behavior, then what legal recourse do you actually have? Now, this is the kind of scenario that many business leaders face today, especially in a tight-knit industry within a sector where companies are both collaborators, but they're also competitors. So let's explore the ethical and the legal dimensions of this situation under the label poaching. Let's start with the ethics of poaching. Imagine another scenario. You're part of that industry association where members regularly meet to discuss best practices and industry challenges. And during these meetings, you share strategies, you share future plans, and you even nominate some of your members for recognition within the industry or sector. You also share your challenges in terms of retaining staff. Now, what if one of those members at these meetings starts to use this inside knowledge to identify and target your key employees, your senior managers, the movers and shakers in your business that are always going to stand out? They know exactly who your top performers are and what it would take to entice them to jump ship. This isn't just a loss of talent, it's a breach of trust. And the very foundation of your association's collaborative spirit is at risk. So this leads us to the ethical question of professional integrity and trust. When you're part of an association, there's an unspoken agreement to work together for the common good. Poaching staff from fellow members can feel like, frankly, betrayal, damaging relationships, eroding a sense of community. And that sense of community is supposed to exist in these associations. You're supposed to be able to trust each other. But ethics is only one side of the coin. Let's look at what the law says about this. So here's a real world scenario illustrating the legal complexities of poaching. Suppose you're the owner of a tech startup in South Africa. You've recently lost a key developer to a competitor within the tech industry in this country. The developer had a restraint of trade clause in their contract, which prohibited them from working for a direct competitor, such as the one that's poached him, for a period. So that period could be for a year after leaving your company or in chunks of multiple years. Despite this, the competitor not only hired them, but also placed them on a project directly competing with the projects that you handle in your company. In this case, you may very well have grounds for legal action based on the restraint of trade clause that was signed at the inception of the employment. South African courts generally enforce these clauses if they're reasonable in scope, they're reasonable in time, they're reasonable in geography. And you could potentially seek an injunction to prevent your former employee from working on that project. Or even you could claim damages if you suffered financial losses as a result of what your competitor has done. Let's take another example, this time involving inducement to breach a contract. Imagine a scenario where a rival company, aware that your star salesperson has a lucrative contract with you, starts wooing them with offers too good to refuse, and they promise to cover any legal fees that may arise if the salesperson breaks their contract with you and joins them. In this case, the rival company could be held liable for inducing your employee to breach the contract. You'd need to prove that they knew about the contract, intentionally caused the breach, and that your company has suffered as a result. Now, this can lead to compensation for damages. What about the delicate issue of trade secrets? Imagine you're running a consultancy firm and your lead consultant, who knows your client's strategies inside out, gets poached by that competitor. A few weeks later, you start losing clients to the competitor, and you suspect your former employee is using confidential information to win them over. If you can prove that your trade secrets or your confidential information has been abused, misused, both the former employee and the poaching company could face legal consequences. South African law is quite clear on this. Trade secrets and confidential information are protected, and their unauthorized use can lead to serious legal repercussions. Let's shift gear a bit and consider the scenario of unfair competition. Imagine a situation where a larger company systematically targets your key employees at all levels, one after the other, to the point where your business operations are seriously disrupted. You can't run your company like that. It's not just about losing a few employees. It's about being left with insufficient resources to compete effectively in the marketplace. Now, in this scenario, you would have a case for unfair competition. Now, although these claims are complex and require substantial proof and evidence, they're worth considering if the poaching is designed to destabilize your business. So what can you do if you find yourself in such a situation? Let's talk about best practices. Firstly, make sure your employment contracts are rock solid. Include reasonable restraint of trade clauses, especially for key employees. Regularly review your contracts to ensure that they're enforceable under South African law, and try and establish a trade in that letter of employment and how you pay your staff member, a trade for the restraint. So you're actually over and above what you're paying them to restrain them from actually competing with you or going to a competitor for a reasonable period of time should they leave your company. Next, engage and talk to your industry association. These associations can be very powerful allies in maintaining ethical standards in your industry. If you suspect unethical behavior, don't hesitate to file a complaint. Associations often have codes of conduct, and they can impose sanctions or mediate disputes. And finally, stay vigilant about protecting your trade secrets and your confidential information. Educate your employees about the importance of confidentiality, and take legal action where you suspect any kind of breach. Poaching staff within the same industry association in South Africa. It's a complex issue, significant ethical and legal implications. Now, it's not illegal to poach people. Companies need to tread carefully, balancing the desire to attract top talent with the need to maintain professional integrity and comply with the law. I want to encourage you to mail me should you have any questions or stories of your own and your own experiences about poaching. Feel free to reach out. I'd love to hear from you. Until next time, stay ethical, stay informed, and stay ahead in your industry.